Well, I'm just wondering, are you waiting for a hearing to assign you as an administrator of a loved one's probate estate? Or maybe wondering when an estate you are a trustee for will be able to finalize now that the courts are closed? Well, that's what we're talking about right now. Hi and welcome. I'm Charlotte Volsch, certified probate advisor and specialist in trust estates. And today I'm joined by Mr. Tom Dominic and Mr. Craig Wilson, attorneys from the law offices of Fullerton, Lehman, Schaefer, and Dominic. And there they specialize in probate and trust, along with estate planning and litigation. So welcome, gentlemen.
Thank you.
Thank you.
I met Mr. Dominic and Mr. Wilson through the Estate Planning Council of San Bernardino County, where my purpose as a member was to gain new insights and accurate information around probate and trust estates so that I could be a better guide for the people I lead, guide, and protect through this often complicated process when they sell real property that they're responsible for in many cities of the Inland Empire and the High Desert. And because of our collaboration, helping people through that process of probate or trust in the properties they're responsible for in the past 8 years, I was confident they would be able to shed light on questions I'm hearing from those waiting for a court hearing to be assigned either as an administrator or a hearing to finalize the probate or trust that they're responsible for. So, gentlemen, I'm wondering, what is the latest date for the courts in San Bernardino County to open?
Well, I'll go ahead and go. Charlotte, as you know, California has essentially shut down all court operations except for emergency matters that are specifically limited by the court rules for each of the superior courts. Currently, you're looking at closure of San Bernardino County courts until April 30. They say through April 30. Riverside through May 1, which is a Friday, meaning they wouldn't start up until the following Monday. Orange County currently is at April 24, but I suspect that that's going to be extended. And then Los Angeles County is currently closed through May 12. Basically the courts have suspended all non-essential functions and are only hearing certain limited emergency type matters. So we're looking at May before we reopen at the earliest, and it's going to subject to change any time unless we see a substantial decrease in the number of COVID cases. I think that the likelihood is they'll extend at least 2 weeks into the mid-May time period, if not the end of May.
Do you surmise would be a realistic time frame for someone that's waiting to be assigned either as an administrator to be that hearing to be held in the courts? You're saying that if the courts open, like you say, being pushed out 2 more weeks, which would be mid-May, what's a realistic time frame for that court date?
So if you've already filed and you have a hearing date that was scheduled between now and the closure time, okay, those are going to be automatically continued. Right now, we're getting notices of continuance anywhere from mid-June all the way up till December, depending upon where your case is located and what type of hearing it is. On initial petitions for probate, there is a rule that says they have to be heard within 45 days of filing, absent good cause. Well, I think we're in the good cause window. So if you had your hearing set after the court reopens, I think those will go as scheduled. But those that were already scheduled during the closure period, they will be put out between 45 days and upwards of maybe 90 days for the initial petition. If you haven't filed yet, you can't file until the court reopens. The only thing that the courts are considering in probate right now are ex parte matters based on exigent circumstances. So let's assume the courts reopen May 15 and you file that day. you're likely going to get a hearing at least 45 days away, if not longer. And then we have a huge backlog now of criminal matters that take precedent over civil and probate. So how that will affect your ability to see a judge remains to be seen.
So if I understand you correctly, there's so many variables stacked up there that are more than just probate or trust cases. And as you mentioned, the criminal matters take precedence when the courts do reopen. So is there anything that someone could be doing to prepare, or are they just sitting in limbo at this time while they're waiting for that court date?
With respect to probate matters, if you're not appointed as the personal representative, even if you're nominated in a will, you really don't have the legal authority to marshal and sell assets. You're basically stuck until you can get a court order appointing you and letters issued. Now, as a practical matter, if need be, you can take steps to preserve and protect property pending the filing of the probate and the appointment of the administrator. For example, if your estate property has been vandalized, nobody's going to complain if you go board it up, okay? No one will complain if you put in an alarm system. And that assumes you have the ability to access your property, et cetera, and there's maybe not other people living there. But there are other things you can do. If estate property or people are at risk of imminent harm or loss, you can go into court and seek emergency relief by an ex parte application. So, for example, in probate court right now, they're considering, and we filed a couple of petitions for ex parte petitions for appointment of a special administrator to take control of property where, for example, there's rental income, there's expenses that need to be paid, or there's an imminent foreclosure, and the lender won't talk to the client. So those are circumstances that you can seek ex parte. Also, guardianships and conservatorships. If you need a temporary guardian or conservator and you can't wait until the courts reopen and you can't wait until whatever your future hearing date is, you can come into court still and seek ex parte relief. You need to lay out why you're coming in on such an emergency basis and what the risk is to persons or property.
Okay, that's good information. So if someone has a current situation, they could talk to you about starting the case and maybe doing that emergency filing even right now. Is that what you're saying?
Absolutely.
Okay.
We've done a few already.
And Charlotte, what Tom's really saying is that each situation is unique, and these people need to be reaching out to their attorneys, their advisors, their real estate advisors to get advice on what to do under their particular circumstances. And as we filter and understand those circumstances, then we can make recommendations. Sometimes it might not be exactly what they want, but it'll be consistent with what we can achieve and how to protect assets and move the matter along. So even with courts closed, they still need to be reaching out to us so that we can prepare that planning and be ready and to move forward.
That's good information because many people are thinking we're all at stall, and my thought was there could very well be something that could be going on, or as you're talking to some of these emergency situations, they can be moved forward as need be so that properties are protected or people are protected or both. So that's very good insight. I had one question come up. If someone's been assigned as an administrator and the judge has requested or required them to have a bond, but they don't qualify, what type of delay or expectation or new options might they be able to take a look at?
That's a good question. There are a number of options available. if someone doesn't qualify, number one is you can ask the beneficiaries of the estate to sign a waiver of bond. And if everybody gets along and trusts each other and they trust the personal representative to do the right job, they might be willing to sign a bond waiver. There is a special form for that. There's all kinds of warnings about, the impact of waiving a bond. But I have many cases where if we have a close family that gets along and there's no issues, we get bond waivers. Secondly, you could, instead of seeking full authority under the Independent Administration of the States Act, you can seek limited authority. And most estates have their primary asset being a house, and it might be worth $300,000, but the person doesn't qualify for a $300,000 bond. Mm-hmm. If you ask for limited authority, you don't have to bond around that value, okay? But the downside is you can't sell the property under the IAEA, meaning you will need to file a petition to confirm the sale with the court. And at that hearing, the court will require a bond be posted for the proceeds unless you put the proceeds in a block account. The third option is if there's a cash in the estate of $300,000 and you don't want a bond for that, ask the court to order it put into a blocked account. Okay. Lastly, many bond companies will allow you to have a joint control agreement between with the attorney and the personal representative, where they jointly control the estate funds.
So that's good information. And so when you say that the control would be between the attorney and the administrator, is that referred to as a secondary bond?
No, there's an agreement that you give to the bonding company that both parties, the lawyer and the client, understand that these funds, the estate funds, are to be held under their joint control, which may require either the opening of an account where both are signers or some other type of arrangement that the attorney might be able to work out with the client, where the attorney opens the trust account and then makes sure the client approves all disbursements from it.
Okay.
So then you basically say to the bonding company, we're going to watch over this money and we'll defend and indemnify you if there's a loss.
If there's a loss. Okay. All right. Very good. And then Craig, if I have I'm overseeing, say, my sister's trust and the properties are sold because of the courts not being open right now, what kind of a delay would I be looking at for everything to be finalized and the funds to be dispersed?
So for most of the trust administrations we do, they don't require court supervision or court involvement. Okay. The only delay we're going to have is if we're giving certain notices and there's time periods to object or time periods for people to make court filings. The courts are treating these closed days like a holiday. So it's pushing all of those timelines out. So that's going to be the only concern moving forward. But as far as trust administrations go, we can do almost everything we need to do to keep administering, moving them along, selling property, obtaining appraisals, preparing tax documents when necessary, and doing filings. Some items are a little slower than usual. I mean, the real estate generally is slower, and we're very cautious with that. Some of our recordings, especially with reassessment exclusions and so forth, are a little bit slower, or we don't get responses in a timely manner. So those are slightly delayed. But again, each circumstance is unique, and we look at each circumstance. And in some cases, we've had pending escrows that were pending before the outbreak, and we've been able to close those throughout this period.
And I might want to add, if you're, Charlotte, I don't know if you're talking about a court supervised trust or non-court supervised. Most trusts, as Craig points out, are not court supervised, okay? Unless it was a court created trust or someone has filed a petition taking jurisdiction of the administration over in the court system, okay? So if it's court supervised, I don't think you can just distribute once you sell property unless you get some type of court order. So the court closures will delay that. And if it's not, as Craig points out, there's no delay in the administration and distribution of the trust. But always bear in mind that before a trustee distributes trust assets out to beneficiaries, they need to make sure, number one, the 4-month period to contest the trust has expired. A trustee is required to send out a notification within a certain period of time after the death of the settlor that the trust is now irrevocable and that there's a 120-day period to contest the trust. You don't want to distribute money out before that time period runs. And secondly, many trustees wait up to a year to distribute everything out because there is a 1-year statute of limitations for any claims that might exist by creditors against a deceased settlor. So if a trustee sold property and is ready to cut checks, you may consider holding back a reasonable reserve for contingencies. Of course, there'll need to be a tax return at the end of the year of the administration. So, but other than that, the crisis really shouldn't delay the administration of a non-court supervised trust.
Very good information to take into consideration, whether we're in this pandemic or not, for sure. And so, having a professional on your team to guide you through the often turbulent waters of probate or trust is essential based on my experience. And having the help in today's world with additional chaos is really crucial. Do you gentlemen have any closing thoughts?
Craig?
Yeah, I certainly would concur. And that we have some, we are constantly reading and studying and trying to keep up on changes in the court system, changes in the administration, some of the effects of the COVID and the closure and the economy, and how that influences the things that we do. And we reach out to experts like yourself and others to help us with the particular assets that we're dealing with or the particular circumstances. But the reality in the world that we live in, that people that try to do this on their own or don't seek out advice are making a grave mistake. That the time that they speak with accountants, attorneys, real estate advisors, financial advisors, is worth the investment in the long run, because it's going to save them a tremendous amount of time and a tremendous amount of headache. And we've been investing in a lot of our clients during this crisis as we continue to work out the specifics of their situation in order to achieve the results that they're looking for.
Well said, well said. And I concur that having a professional on your team may initially look like a big expense, but in the bigger picture, it's an amazing investment, because it doesn't only save you time, but it saves you losses. Losses in equity that you maybe have forthcoming, and losses in bad choices because you didn't have accurate information, and definitely losses in your time.
I do see, Charlotte, a lot of times when I'm over in court where an executor or administrator has attempted to probate the estate themselves.
Yes.
And in order to save the money and expense associated with hiring a lawyer. But I'll tell you, they get into a lot of problems because it is a complicated process. They try to sell property or distribute it without getting any advice or court order, or without seeking appropriate professional advice from a realtor such as yourself. So I've seen it time and time again where they're facing fines, what we call sanctions, or surcharge orders, and for making mistakes that cause losses to estates. So it's really the money you think you're saving, it's not realistic considering how much it's going to cost you. Some people even hire paralegals and spend more money than they would have spent had they come to a lawyer in the first place. So
So true. And, you know, the attorney fees are all mandated through the state. So you're getting a professional help with all of the court dates met, all of the timelines met, all the proper filings done. So you're protected not only as the administrator of the whole estate, but also you're protected on the properties so that there's no after effects in the next 2 to 3 years. And so, you know, we all here study the markets, study the laws, the rules, and everything, as Craig mentioned, as we continue to do right now. And that's why we're coming out to you with this information as you're sitting sort of in a limbo state with lots of new questions coming to mind, so that you have an area of clarity and a place to plug in for accurate information on a go-forward basis. So thanks for joining us. Leave a comment below if you have questions or need help in your current probate or trust situation. Ring the bell to be notified of upcoming additions to the channel, and we look forward to seeing you the next time.